Clarence Thomas enters the danger zone. The matter of Clarence Thomas' relationship with billionaire Harlan Crow has now entered new territory, treacherous for the justice and the court on which he serves. Until Thursday's ProPublica's report disclosing Crow's purchase of property owned by Thomas and his family in 2014, the story was about Thomas' judgment, or lack thereof, in accepting large amounts of luxury travel from the Republican megadonor, and whether he had failed once again to comply with federal financial disclosure rules. The latest revelation escalates the situation to a new and concerning level. This time, Thomas directly received money from Crow, perhaps in excess of the market value of the Chatham County, GA, properties that Crow purchased from Thomas and his kin. This is no longer about receiving personal hospitality. It's about a financial transaction between Thomas and a GOP donor who has also subsidized his vacations. There is no doubt that the sale of personal real estate to Crow should have been reported on the Justice's financial disclosure form for 2014, and there is no excuse for failing to do so. The most logical explanation is that Thomas, whose relationship with Crow had already been the subject of unflattering news reports, wanted to keep it from public view. Thomas' relationship with Crow and the accuracy of his financial disclosure reports must now be fully scrutinized by the Judicial Conference of the United States, which oversees the federal judiciary and may refer the matter to the Justice Department for additional action. As Chief Justice John G. Roberts Jr. surely understands, this is a problem not just for Thomas but also for the court and its public legitimacy. According to the ProPublica report, a company controlled by Crow bought the properties in Savannah, Georgia, for $133,363 from Thomas, the family of his late brother, and his mother Leola Williams, who continued to live there. Soon after the sale was completed, contractors began work on tens of thousands of dollars of improvements on the two-bedroom, one-bathroom home, which looks out onto a patch of orange trees, ProPublica reported. The renovations included a carport, a repaired roof and a new fence and gates, according to city permit records and blueprints. Crow told the publication that the transaction was at market rate. The year before, he bought two other properties, a vacant lot and a house on the same block for $40,000. Thomas, in earlier financial disclosure forms, listed his one-third interest in rental property in Savannah at $15,000 or less. Crow said his interest in the property was to one day create a public museum at the Thomas home dedicated to telling the story of our nation's second black Supreme Court justice and approached the Thomas family about my desire to maintain this historic site so future generations could learn about the inspiring life of one of our greatest Americans. Fine, but the real estate deal raises several questions, among them, why didn't Thomas report the transaction on his financial disclosure forms? And did Thomas' mother pay Crow rent as he improved the home and paid taxes on it? ProPublica posed this question to Crow, but he did not answer. Thomas has said that he didn't have to disclose his Crow-paid vacations under the exemption for personal hospitality, a dubious defense when it comes to his use of Crow's private jet. Thomas had reported travel at Crow's expense before he stopped disclosing it in the wake of negative news stories. But Thomas' obligation to report the real estate deal couldn't be clearer. He had reported the property as an asset. Selling it was a transaction that necessitated disclosure. The Ethics in Government Act requires judges, like other senior officials, to file annual financial reports, and sets out the consequences for failing to comply. It further provides that the relevant party, which in the case of judges is the Judicial Conference, shall refer to the Attorney General the name of any individual which such official or committee has reasonable cause to believe has willfully failed to file information required to be reported. A violation can result in a fine under the Criminal Code. Did Thomas act knowingly and willfully in failing to report the property sale? One relevant consideration: the Judicial Conference has seen this kind of non-disclosure from Thomas before. Like other senior officials in government, justices must disclose their spouse's sources of income, although not the dollar amounts. On his financial disclosure forms, Thomas simply marked the box labeled "None" for non-investment income earned by his wife, Virginia, Ginny Thomas. In fact, she was employed by the House Republican leadership, Hillsdale College and the Heritage Foundation, earning more than $1.6 million from those sources, according to separate records compiled by Common Cause and the Alliance for Justice. Though mass explanation, a misunderstanding of the reporting rules, was unconvincing then, and relevant to the situation now. As the instructions for filer's spouse state, report only the dates and source of earned income from any source that exceeds $1,000. Second, Thomas had complied with those rules for the previous decade, reporting the source of his wife's income during his years as chair of the Equal Employment Opportunity Commission, when he was a judge on the D.C. Circuit, and for the first 5 years of his tenure on the Supreme Court. The justice is a repeat offender. Judges aren't eager to police their own, especially not a sitting justice. Human nature and history suggest the judicial conference won't do a thing. But the Georgia real estate deal will make that dodge harder. And the law requires otherwise. Clarence Thomas enters the danger zone. The matter of Clarence Thomas' relationship with billionaire Harlan Crow has now entered new territory, treacherous for the justice and the court on which he serves. Until Thursday's ProPublica's report disclosing Crow's purchase of property owned by Thomas and his family in 2014, the story was about Thomas' judgment, or lack thereof, in accepting large amounts of luxury travel from the Republican megadonor